So thank you everybody for joining the seminar today. We're going to be discussing primarily the judgment of the ECJ in 713/23 Cupriak Trojan and its contribution to the development of EU law in the fields of citizenship and equal treatment. So just by way of a very, very brief background before I pass on to our speakers for today, at the end of November, the Court of Justice ruled that Poland has to, first of all, recognize the same-sex marriage of two Polish nationals who married while they were living in Germany. And secondly, that it has to transcribe their marriage certificate into the marriage register as a necessary requirement for recognition. And then at the end of March this year, the Polish Supreme Administrative Court gave effect to that judgment, ruling that the certificate has to be transcribed into the marriage register in Warsaw. So these rulings matter hugely for the individuals involved, one of whom I think is here, and they represent an important step towards equal treatment in countries that don't yet recognize same-sex marriage in their domestic law. The judgment also has a major impact and it represents a major development in EU law in terms of how the court reached its conclusion. So the applicants here were able to rely on their EU citizenship status under Article 20 TFEU on the basis that they'd exercised their free movement rights under Article 21, and that allowed them to invoke the right to equal treatment under the Charter uh, as the basis against their own member state of nationality. So it's these two dimensions that we're going to be looking at today, that citizenship hook and the equal treatment guarantee. So we've got five speakers. Our first is Milena Adamczewska-Stachura. She's an advocate who is part of the legal team that represented the applicants before the Court of Justice and the Polish courts. And she's going to give us an overview in the beginning from the perspective of the people who litigated the case. Our second and third speakers are Professors Catherine Barnard and Professor Fiona Costello from the Universities of Cambridge and Birmingham, respectively. And they've done extensive empirical research into migrant statuses and the relative weakness of EU citizenship status in the UK following Brexit. Our fourth speaker is Professor Alina Trifonado from the University of Cyprus, whose work pivots around free movement law and the protection of LGBT plus rights in EU law. And she's going to consider the impact of the judgment on equal treatment more broadly. And then our fifth speaker is Professor Adam Bodnar. Until last year, he was the Polish Minister of Justice. And before that, it's Human Rights Ombudsman. And he's going to place these cases in their Polish legal context and reflect on what comes next. So what makes this seminar, I think, particularly timely is the fact that we have the judgment from Commission in Hungary from last week. So I think it's going to be important to think about how that judgment interacts with Cupriak Trojan. And as you know, the court for the first time there found an autonomous breach of Article 2 against a member state. And what I think is interesting is that it did that on the basis of violations of the same charter rights that are at issue here. So Articles 1, 7, and 21 of the Charter. And what I find interesting and what I'm curious to see how this is discussed in the coming weeks is the effect to which those charter rights have now been, I think, severed from this prior requirement of free movement. That was the issue, the basis for relying on those rights in Cupriak Trojan. So I think that development gives our discussion today an added dimension. So we're going to begin with short presentations of up to 15 minutes from each speaker. And then at the end, we'll have a group discussion about 30 minutes. So if you can save your questions then until the end. So Milena, would you like to start by giving us an overview of the case?
Of course. Hello, everyone, and it's a real pleasure and honor to be here and to tell you about how we litigated the case and what led into it. Just as a start, I will also mention names of my other colleagues of our legal team. So it was all advocates, Anna Mazurczak, Paweł Knut, and Artur Kula. We litigated the case all together, four of us, and we really like to mention that it was a real teamwork to build these arguments. But to jump into the topic, first of all, also a side note that I must say that it's been amazing weeks since December, basically, and since the judgment, and it's beyond my expectations how much is discussed in also Polish public debate and how much is on the mouths not only of academics but basically everyone. And I strongly believe that this only shows how important it is and how big change it brings. So that's a side note to start. And in my presentation, I will firstly briefly discuss the legal landscape. I know this is the topic of later on presentation of Professor Adam Bodnar, but also it's important to mention that to explain how we build our arguments. Later on, I will shortly say what we litigated on the national level, how it led to proceedings before CJEU, and how we read the judgment from our perspective. So, what were the most important elements, what we wanted to receive, what we received, where are the question marks, and what's the most crucial in result. So, to start with this legal landscape, of course, this is obvious for all attendees. I believe that there's no family rights protections of LGBTIQ individuals in Poland. That was also a matter of ECHR judgments of Przybyszewska, Formela, Szypuła, Andersen, and others. So really a strong line of ECHR judgments already. Of course, a lot of Polish couples for years have been traveling abroad to other EU member states to get married there. And what they held in hand was their foreign marriage certificate, which in theory, according to Polish law, should have been treated the same as a Polish marriage certificate. This is due to the clause we have in Civil Status Act and Supreme Court judgment interpreting it that foreign civil certificates have the same evidential effect as Polish certificates. So therefore, holding the foreign one in hand, couples should be able to actually go to administrative body and argue for certain rights. However, this is only a theory, and this is something that we managed to clearly explain to CJEU, because this is also clearly mentioned in the judgment as circumstances of the case. That for the applicants, it was also a little bit chaotic how Polish administrative bodies treated their foreign marriage certificate. For the applicants, that was a matter of change of name on the basis of the marriage they concluded, and the matter of properties they had. So there were two different registry courts in Poland. One of them actually considered the change of name, the other one didn't. And that was the argument for the court that indeed in Poland, administrative bodies differently treat this situation of holding only foreign marriage certificate in hand. At the same time, we have these provisions in national law of transcription. Transcription for a lot of years, like when it was established in law, was considered rather technical thing. And it is very technical, and it's actually very automatic for different sex couples. And this is, again, a very important argument that CJEU considered. Because this is how we build an argument that while different sex couples can easily access transcription, same-sex couples can't do that, and they don't have any similar equivalent. And that was actually the ground for a discriminatory argument. So transcription is quite easily obtained for different sex couples. It's actually also compulsory. This is an interesting fact because while it's compulsory, it can be also refused on the basis of public order clause. And this public order clause was for many proceedings used by all national courts in these kind of cases. When we litigated transcription cases to ECHR, the courts all the time confirmed that public order clause read together with Polish constitution and with Polish family law state clearly that marriage is only a union between different sex people. So therefore, transcription is also not possible because it will create the equivalent of marriage. Also, a side note that for quite a lot of academics, it was also for many years not clear what kind of effect transcription has. And this is, again, a very important element for CJEU judgment that in the case we discussed at the same time, transcription and recognition. For some academics, transcription basically wasn't an equivalent of recognition. This is something that is important that the court clearly stated, but I'll also get back to that. So when we actually started the case on national level, knowing that one of the applicants has also German nationality and that we clearly had here this element of free movement to Germany, we knew that it is a good, strong case for reference to preliminary ruling. We didn't manage to convince the first instance voivodeship court, and our complaint was rejected. But before Supreme Administrative Court, we knew that it's either rejection or complaint of our complaint or request for preliminary ruling, and we managed to convince the court to do that. What was actually important for the judges was that we were at the same time after Fedotova ECHR judgment. So we argued that situation that we had in Poland before Przybyszewska, but already after Fedotova, has to be resolved finally somehow, and that for EU citizens who exercise their freedom of movement, the way of asking CJEU how to deal with the case is a way forward. And actually, the justification of preliminary question is, I think, really great piece of argument already. Like having read that back when it happened, we were very hopeful about the case. But what was our worry is that what CJEU will do is it will repeat the reasoning of Pancharevo. And here I need to explain shortly also that in our law firm, like we also litigated the Rzecznik Praw Obywatelskich case that was the one very similar to Pancharevo. There was a court order there, not a judgment, that it referred to Pancharevo case. And the situation of children with same-sex parents who were born abroad and therefore has foreign birth certificates is a case that cases that we deal with and cases that we had to like have a close look to. Unfortunately, Pancharevo judgment, in my opinion, wasn't implemented properly in Poland, and it wasn't because the court was very vague of whether explaining how the member states should actually recognize same-sex parenthood. It mentioned recognition of the bond that the child has with both parents, but referring to situation of Polish law, it did not mention transcription as an obligatory way of this recognition. What happened, therefore, is that Polish administrative body, they actually issue IDs for children mentioning only one of the parents. Usually it's a mom that gave birth. The other parent is completely ignored, and at the same time, children do not receive Polish birth certificates. So considering that, to compare that with situation of same-sex couples that we have here in Cupriak Trojan, it would be if the court said that, yes, member states, you need to recognize the marriage. If the court didn't say that it's transcription, I'm almost sure that what would happen in Poland again is that we would receive another rejections for transcriptions and only a general view of maybe recognizing somehow magically foreign marriage certificate would happen. Like in practice, it will not change anything. Therefore, it was the most important element of the case for us to actually convince the court to be precise and to make a step farther from Pancharevo, even a step farther from Mirim, and be precise about transcription. And as you all probably know, if you had a look into the judgment, we managed to do that. The court was very specific about that. It's the general comment about recognition, but taking into consideration circumstances of the case and situation of Polish legal landscape. In Poland, it has to be transcription. Firstly, because it's the only effective practical way. Second of all, because doing otherwise would be discriminatory to same-sex couples. And here we get back to what I've mentioned already before, that if it is actually so easy for different sex couples, same-sex couples should have the equivalent right. Now, taking to the maybe some question marks that we have in the judgment, what is the most important for other couples now in Poland that are in similar but maybe not identical situation to applicants to this case is how Polish courts and administrative bodies will consider the element of strengthening family life abroad. So whether the freedom of movement here considered as actually traveling to another member states just for a few days of getting married there and then coming back to Poland, whether it will be enough or if administrative bodies and courts will somehow look for evidences of maybe longer stay and strengthening family life for certain period of time. Actually, after yesterday, we have already, I hope, a good sign what will happen. Of course, we want protection to be as broad as possible, so we hope for the courts not to be so detailed about this argument. And already one voivodeship court in Lublin gave the judgment yesterday in the situation of the couple who actually traveled abroad only for a few days. So it was I think a great success, and we hope that other courts will continue this line of argumentation. Another important question which still arises from the judgment is which rights the applicants in this case and also all other applicants in other cases will be able to derive from their marriage certificate, the Polish one, already after transcription. So the court here mentions all the rights that they can derive from EU law. This is, of course, very broad. We can read it also together with the judgments of ECHR, and actually reading these two together, we have a great overview already of rights in the fields of taxes, in the fields of mutual protection, in the fields of all kinds of oh my God, sorry, I forgot the name. Yeah, like anything that can be derived from EU law, and this is our hope that administrative bodies will actually confirm this interpretation and put it into practice by actually considering all the rights that married couple have in Poland to be applied to the situation of applicants. Okay, and to shortly sum up, because I think I'm running out of time, just a short mention also of situation we have in Poland now with this particular judgment of Supreme Administrative Court. The court made it very clear that its judgment must be implemented within 30 days after the after the file of the case are actually took back to the administrative body. The time is not running yet. The files were not returned, but as you can imagine, 30 days is very short. And this is important because our current government states that some forms needs to be amended to be able for the judgment to be implemented. The court made it clear that the forms and how actually the civil act is built and named is not important here, and that it should not be a problem if we're speaking of the situation of human rights of the applicants. So very soon, we hope that both judgments in this case will be put into practice by transcription and recognition of marriage. However, we are still not clear what will happen with all other similar cases. And I guess this is also the question that we'll discuss further here today. So thank you very much.
Thank you, Milena. So we'll move straight on now to our next speakers. And if you can save up any questions anybody has, we can deal with them at the end. So I'd like to invite Professors Fiona Costello and Catherine Barnard.
Well, thank you very much. Thank you very much indeed for organising this and for that very interesting introduction to this fascinating case. I want to say a couple of words by way of introduction, and then I'll hand over to my friend and colleague Fiona Costello to talk more specifically about the issues with citizenship in the post-Brexit context. I think this judgment is fascinating, and I see it very much as a precursor to the ruling in the Commission on Hungary case. Now, although the court does not dwell on values in this case in the same way as it does in Commission on Hungary, where obviously the question of values was front and centre, it is noteworthy this is a Grand Chamber decision. They clearly knew it would attract considerable amounts of attention. And I think what you see here is, of course, although the case was largely pegged on the free movement issue, i.e. the fact that the couple had been married in Germany and came back to Poland, in fact, that gave the court license to take quite a broad reading of the application of the Charter superimposed on top. And of course, as we know, the principle of equality is one of the values in Article 2, and it's a value that the court has long recognised, going way back to those very early cases like PNS, which was a case about the rights of trans people not to be dismissed under then EU sex equality law. So equality has always been an important value. And I think what's really interesting here is how the court has used a combination of the free movement provisions plus the Article 21 of the Charter in particular to essentially shoehorn the requirement to liberalise somewhat the Polish rules in respect to recognition of same-sex marriage. And this is obviously a really important issue for Poland as a country. We've heard how the lawyers for the couple have done an extraordinary job in making the legal argument, and in so doing, removing one brick in the pillar of Polish law that only heterosexual couples can get married. Now, for those of us who have friends and relatives who are in same-sex marriages, of course, we see this as a liberal judgment, an important judgment. I do, however, recognise that there are many people who don't share this view. And the question is whether the emphasis now in post-Commission Hungary on values and the fact that the values in Article 2 are freestanding and any manifest and serious breach of those values can lead to a finding of breach of Article 2 in the context of Article 258 enforcement proceedings. And I think it's quite important to remember that Commission Hungary was different because it was enforcement proceedings. It wasn't a case that started in the national court like the Trojan decision. What we're seeing is such an emphasis on values, and that raises a question about whose values. And the values are the values of a liberal Western court, and does risk setting up a conflict between the original Western states and then the subsequent accession states, the Central and Eastern European states. And the question is, I think, longer term is whether the court might have gone too far in recognising values, albeit, of course, in the Hungary case, those values had been significantly undermined by this very strong piece of legislation. That's not the case in the Trojan case. And of course, the reasoning, as we've just heard from the lawyer in the case, the reasoning in the Trojan case was carefully constructed around free movement. But this does raise the interesting question then, what would have been the position had the UK still been in the EU? Would the court have gone so far, so fast in respect to values in a decision like Hungary? I can well imagine that had there been a British judge still at the court, that the Trojan case would have been decided much as it has been, because it's constructed under the broad edifice that we know about, i.e. that there's obstructions to free movement which couldn't be justified, and then with some charter dotted on top. But whether a court which would have included a British judge would have gone as far as it did in Commission Hungary is another matter. And that leads me to hand over to my colleague Fiona to talk a little bit about what has happened to Polish and other nationals in the post-Brexit world. Poland. Fiona, the floor is yours.
Thank you very much. I'll just share my screen, one moment. Okay. No. I'm sorry. Can everyone see that? Okay, I'm having some trouble with my screens.
Can you make it? It's not. We can't see it as full screen, Fiona.
Okay. Has that worked?
No. Oh, it has now.
Okay. Excellent. All right. So thank you very much for the invitation to be here. And thank you, Catherine, for that introduction. So kind of building on that context, I will talk through some of our empirical insights, as Catherine said, from EU citizens who are living in the UK. And increasingly, our research is showing our thinking about, in fact, applying for British citizenship as the most secure way to secure their rights post-Brexit. I think we're all kind of familiar with the benefits associated with EU citizenship, and in particular associated with EU free movement, which allows people to move to other member states, to live there, to build their lives. And it is through movement, this free movement, that many of the associated rights also become available, a key issue for the purposes of today. So these include access to work, social benefits, education, the ability to live with family members, etc. And as we know, the Court of Justice has repeatedly said EU citizenship is meant to be the fundamental status of member state nationals, and free movement is a key way that that status is given meaning to in everyday life. That said, we also know that access to these rights is not straightforward. Many of the rights linked to free movement are conditional. Residents' access to welfare, if needed, and housing support are often tied to economic activity or to self-sufficiency. And this means that economically inactive EU citizens, such as carers, people between jobs, people with interrupted work histories, or people in less formal work situations, as are many of the people that we've been researching in the UK, are much more likely to fall through the gaps. So while free movement is presented as promoting equality and inclusion, in reality, it often works through a set of qualifications that favors continuous participation in paid work. So that's the kind of EU context. The post-Brexit context, which I'd like to focus on a little bit more for today, brings these issues of the kind of associated rights of EU citizenship and free movement into sharp focus. For EU citizens in the UK, certain rights, of course, have been preserved through the withdrawal agreement, including through domestic schemes like the EU settlement scheme, the scheme set up to allow EU citizens already resident in the UK to continue to live in the UK by making an application to the EU settlement scheme. However, these protections are limited in scope. They're fixed in time, they're conditional, and they are kind of no longer part of the broader system of EU free movement law or the case law of the Court of Justice, with now time-limited references to the Court of Justice available for 8 years after the end of the transition period. They withdrawal agreement delivers more restricted family reunion rights, and of course is dependent on domestic implementation and trust also, which is a key issue that I'll come back to that's really come out as a key theme in our research with EU citizens themselves. The dependence on withdrawal agreement protections shows how important free movement was as a framework through which EU citizenship actually delivers rights, and how fragile those rights can be or can be perceived to be once that framework is removed. One clear response that we've seen to this uncertainty is that of naturalization, as people seek to a more secure legal status and a more reliable way of protecting their rights by instead applying for British citizenship. So our question and our kind of contribution for today, I guess, is to share some of these empirical insights as to why our EU citizens in the UK increasingly kind of telling us they are looking instead to become British citizens rather than relying on their EU rights. So the empirical data I'll share comes from the work that we've done. So we've undertaken about 50 one-to-one interviews with EU citizens living in the UK, as well as 13 focus groups over a number of years with about 90 EU citizens, again, asking questions around their kind of pre-Brexit and post-Brexit in terms of how rights are working and changes they're experiencing. And just for kind of geographical reference, most of our work takes place in the town of Great Yarmouth, which is a small seaside town in the east of England, and was actually a town which has had very high levels of EU migration due to kind of local work opportunities in the town, particularly low-paid, low-skilled work in poultry factories. But it was also the 5th highest leave vote in the UK referendum to leave the EU. So there is a lot of support locally for the UK to leave the EU, as well as significant migration. So in terms of some of the reasons people have been telling us they are applying for British citizenship and not relying on the EU settlement scheme to prove their rights was firstly around the kind of introduction of the EUSS, the domestic scheme, in 2019. Initially, there was a deadline. There was a deadline for an in-time application, and there was much fears of a cliff edge where people who didn't make an application in time would lose their rights overnight and suddenly find themselves without legal status in the UK. And although the late applications were possible and are still possible to the EU settlement scheme, it was this initial grounding, I think, in anxiety and uncertainty from the very early days that set people up in our conversations to thinking about, how do I make my status more secure? This doesn't feel secure, and I'd like to apply for something that does. Alongside this, the EU settlement scheme doesn't provide any physical proof of status. It's a digital status. So if one needs to prove their rights, they need to log on and generate a kind of share code that they can share with people to prove that they have status in the UK. And there are still a lot of fears at borders when people are traveling that they will be able to rely on this status, this digital status, to be able to gain entry back into the UK, but also proving your status day to day if you don't have these digital skills, if you don't have Wi-Fi, etc. There's a lot of practical issues at hand, whereas a passport is a physical document, which makes it much easier to prove your rights. As I said, a key theme that's come up from those that we've spoken to is that of trust, and trusting that the government will continue to enforce their rights. And we have a quote here from an EU citizen who just said, "I don't trust the government, I don't trust them to make our life easy, and therefore I want to apply for British citizenship because I feel they can change the rules whenever they like, and I'm anxious about what's going to happen." Or also before they increase the price of citizenship, which is a barrier to citizenship, actually, the cost. We have many, the literature refers to something referred to as strategic citizenship, evidence of this in our research with EU citizens as well, that people are applying for British citizenship in terms of strategy. And many have reported they're applying for British citizenship so that they will be able to leave should they want to, and return also, so that would continue their rights to exercise their EU free movement rights, but also be able to retain that link to the UK if they have spent a long time here. Many, particularly parents that we spoke to, and specifically women, we've interviewed a lot of women in our research, spoke of applying for British citizenship as an investment in the future for their family members. So particularly if children are in school already, they want, and this is the country where the children are growing up, they wanted them to have British citizenship in line with that. And also those who refer to it as a kind of entitlement. So I'm entitled to British citizenship, therefore I should get it. I've lived here the legally required time. It's something I'm entitled to. I should have. And then some others who refer to it as being an additional social status, the strategic citizenship. Again, this idea of citizenship a la carte, where you are able to present a number of different passports and benefit from the one that benefits you most at the time that you need it. So in many ways, it's perhaps quite obvious that naturalization here, applying for British citizenship, is a very rational response to what was a very uncertain situation. And people naturally wanted to look for ways that they could secure their rights post-Brexit. I think also in many ways it speaks to the strength of the fundamental status and the rights offered by EU citizenship and the associated free movement rights, that pre-Brexit EU citizens didn't feel the need in large numbers to be applying for British citizenship, that their rights were secure. And of course, in a post-Brexit world, perhaps that feeling is that that is no longer the case. In other ways, Brexit also allows us to see the success of free movement in terms of how many individuals had indeed exercised their free movement rights in moving to the UK, as well as with accompanying family members. There's thought to be as many as 6 million people, 6 million EU citizens who have moved to the UK, certainly who have applied for status under the settlement scheme. When we are talking to EU citizens, of course, these are very serious conversations indeed for those who are from member states who do not allow dual citizenship, and therefore it becomes quite a significant decision. If you are to apply for British citizenship, you will lose your EU citizenship. And particularly, again, parents spoke about this in the context of children and it deciding kind of the future of their lives in that way. Interestingly, often naturalization is framed as integration, that it is a way to integrate into the host member state or non-member state in the case of the UK. But actually, for those we spoke about, I mentioned briefly, in conversations, it was framed more as a freedom than as a process of integration, i.e. I will apply for British citizenship so that I can leave, but I have the right to come back should I choose to do so. So not so much about integrating into the UK, but in maintaining that freedom that was there pre-Brexit also, and doing that via citizenship application. And then finally, similar to a theme that's come across in a lot of our work, particularly because our work is focused on low-paid migrant workers, EU migrant workers, is that this is once again a tale of two citizens. Applying for citizenship is incredibly expensive in the UK. There's also English language tests, life in the UK tests, etc., biometrics, the costs of passports, and therefore it stratifies groups into those who can afford to make the application and those who cannot, and will continue to do that as we move forward. But perhaps for children, it's a much more achievable option for parents. But we will, I think, in the UK continue to see a number of kind of mixed citizenship families, EU families, who hold a number of passports, or maybe family members who hold different passports. But I'll leave it there for now, because I'm sure we're low on time. But thank you very much.
Thank you both very, very much. We are low on time. Can I just ask one super quick question, a yes/no question? Am I right that if an EU national acquires UK citizenship, they lose their rights that are derived from EU citizenship? Like, for example, third country national family member residence rights. Are they treated as UK nationals only?
Oh, I don't think so. I don't know, Catherine, if you I think
Sorry, no. I
I
I understood that's what you said, but don't worry about it.
Okay.
We can come back to it later.
Okay.
Thanks. Alina.
Yes. Okay. Let me just share my slides. Are they shared?
Yes.
Okay, great. So thank you very much for the invitation. It's great to take part in this seminar. I have really enjoyed it so far. So just to thank you as well. Thank you to the legal team that took the case and to the applicants, because it's been the most interesting case for me, for my own research interest in the last few months. I even dare to say more interesting than the Commission against Hungary one. So I have been asked today to focus mostly on the contribution of this case to the equality rights of persons under EU law, EU free movement law, citizenship, and obviously I will take this by reference to the case. So I'm starting just with my own views on the overall significance of the ruling. So obviously this case is extremely important. It's a landmark development for cross-border recognition of same-sex marriages within the EU. It definitely moves beyond earlier ECJ case law, obviously the Coleman case, because it's not limited to recognition for a specific purpose. The emphasis in this case, which wasn't there in Coleman, is on the continuation of family life established or strengthened in another member state. And there is also, as was said in previous speeches, greater engagement with fundamental rights. And in particular, in this one, a novelty is that there is reference and engagement with the prohibition of discrimination based on sexual orientation, which is actually, it is said in the judgment explicitly that it is a general principle of EU law. However, again, as said previously in this seminar, it is still grounded on free movement of EU citizens, which means that its basis is the functional approach, but of course with more emphasis on fundamental human rights. Okay, now, obviously the hook in this case for the fundamental rights is citizenship. So if we didn't have free movement, if we didn't have two union citizens, the court wouldn't be able to analyze the case also on the basis of fundamental human rights. And in this case, like in previous cases involving LGBT applicants, and in particular cross-border recognition of family status, the court started using Article 7, and in particular the right to respect for family life. That's classic, and in doing so, it actually made reference to Article 8, ECHR, and the relevant case law, in particular the case law of the European Court of Human Rights, which requires signatory states to establish a legal framework for the legal recognition of same-sex marriages, or same-sex relationships, and as well for the cross-border recognition of same-sex marriages. Now, as regards fundamental rights, however, these were only considered at the justification stage, as is usually the case. And however, in this case as well, they came back when the court was providing its guidelines as regards the implementation of the judgment. So I think that, again, is something which is quite important. Now, since I'm focusing on the obligations that are arising from the chapter with regard to this matter, and in particular the cross-border recognition of same-sex marriages in the context of free movement, the court, as I said before, relied on, but used as its basis, the case law of the European Court of Human Rights on Article 8. And from this, it said that in addition to the requirement to recognize same-sex marriages for free movement purposes, as this is necessary in order to prevent obstacles to free movement, this is also necessary as in order to respect the right to respect for family life. Okay. So that's the first step. But then the court also said that member states, however, retain discretion regarding the procedures for recognition. But then it said, but these procedures must not render impossible or excessively difficult the implementation of free movement rights. So that relates to free movements. And then it brought back the human rights considerations, noting also that these procedures must comply with Article 21 of the Charter, and in particular must not discriminate on the basis of sexual orientation. That, as I will say later, is really very important when it comes to the implementation of the judgment. It's one of the aspects of the judgment that has not been very clear and requires further clarification, possibly in future rulings. But it's very important because it actually limits the discretion of member states quite importantly. So now, there are two things which are not very clear from this ruling, two very important things. The first one is, what does the application of recognition really entail? And there are two possible approaches. The one is recognition of the marriage as a marriage. And when there is an obligation of full transcription, like is the case in Poland, where this is the only way to recognize a marriage, this means, okay, that's full transcription, the marriage is recognized as a marriage. Or there could be recognition as a marriage without transcription. Don't ask me about the details of this because I'm not very good with these procedural aspects. Or there is the other option of recognition of the effects of the marriage, which is actually the approach suggested by the Advocate General in the case. What this would mean is basically a recognition of the couple as a couple, but without the relationship being considered a marriage, which would basically be downgrading of the relationship to another status like registered partnership. This is what is currently required and considered acceptable for the purposes of Article 8 ECHR through cases like Orlandi and Formella in the European Court of Human Rights. But even that obligation, so even if the ruling is read as imposing this lower, let's say, obligation of downgrading, this being acceptable, again, it's not clear what this would require. Does it mean that this will now require automatic conversion of the marriage into a registered partnership? Or would it even be possible, as is, for instance, the case in Cyprus, where I am, for the member state to tell the couple, okay, look, if you want to continue to be recognized as a couple, you can go enter into a registered partnership in my territory, and then you will be recognized as a couple. So that's this issue of recognition and what it really entails is one of the important issues that remains unclear following this ruling. And the second point, which is actually what I'm going to focus on, is the rights that follow from recognition. So in Coleman, as I mentioned before, the court clearly limited the obligation of recognition for a specific purpose, which was family reunification. In this case, there isn't something like this because after all, anyway, the applicants didn't claim that we are looking for recognition for this particular purpose. So in my view, it seems that the obligation of recognition is for all legal purposes. But the question, of course, is what would this mean? Would it mean only for EU-derived rights? In my view, for sure, these are included, but this would be very limited because basically this is more or less what was said as well in Coleman and VMA. It's likely, and I really believe that these are included, economic and social rights that are attached to married couples will be extended and need to be extended to married same-sex couples that came from other member states. So this will definitely include pensions, insurance, joint taxation. And actually, this is not a novelty of this case because these rights were already granted under European Court of Human Rights case law. This started being developed already in the 2000s. And also we have EU anti-discrimination case law, which established like the Maruco rumor, Hay judgments, which established that registered partners in member states that there is no same-sex marriage should be treated in the same way with regard to employment-related benefits. So all these now will be able to be given to the couples that get recognition via this ruling. But there are certain rights, obviously, which are much more controversial, like parenthood-related rights, that I'm not sure, and it's not clear, obviously, from the ruling, whether they would need to be extended now to the couples that exercise free movement rights, same-sex married couples, and can enjoy recognition via this ruling. Okay, so this would be one of the issues that we will need another case, I think, in order to get clarification. Of course, citizenship and the Charter, and in particular Article 21 of the Charter, which has been mentioned clearly a few times in this case, push towards substantive equality and not just formal recognition. As I said in something I have written, and it's currently under review on this case is not about access to the right to free movement and residence, as was the case basically with Coleman. But this case is about what happens after access to this right is granted. So, and in particular, this case called the court to clarify what leading a normal family life, which has been repeated in the court's case law before but hasn't been clarified, would require in this case. So, when it comes to equality, well, the question is, we have a big question mark, because for sure it has been used by the courts, Article 21 of the Charter, in order to say, well, we need recognition. This is required because of free movement, but also equal treatment. We need to have equality as regards the recognition process. But the court is silent as regards the role of equality and non-discrimination when it comes to the rights that will be able now to be claimed by married same-sex couples via this ruling. And actually, this reflects the approach of the court, which is rather incremental. So rather than making big statements and big steps and deciding everything, anyway, that's also the nature of preliminary reference procedures. It's answering the questions that it has in front of it. So it didn't need, in this case, for instance, to deal with the specific rights that will be claimed and all this. But I think in the future, especially in the light of Commission against Hungary and the values and all this tension between, on the one hand, fundamental rights under EU law, whether these are free movement rights, rights stemming from union citizenship, fundamental human rights, and the EU values, clash. This will continue clashing with areas of exclusive member state competence like substantive family law, and with the issues which are considered to be central to national identity. So this case is one of the cases that exactly expose this tension that exists in the EU and has become even more obvious following the major enlargement in 2004 with the expansion towards the east. So it will be very interesting to see in future cases how these questions that remain unanswered following this ruling will be answered, especially in the light of populism, far-right, the rise of far-right, and all these issues that currently are there in the EU. Thank you very much.
Thank you. Thank you so much. Okay, so now Professor Barnard.
Ladies and gentlemen, thank you very much for convening this seminar. Thank you, Dr. O'Neill, for invitation and for those wonderful presentations. I will do my best to present more or less social, political, and legal perspectives on this case, because I think it is important not just to stick to this case as just one another case coming from the Court of Justice, but rather to look broadly at what is happening in my country and what kind of evolution Polish public life gets through as a result of this judgment, and why it was possible at all to have this judgment right now. Please look that we are just more or less 2 years, almost 3 years, 2.5 years after the democratic transition in Poland. After coming back from a period of illiberalism, it was a period that had a very strong effect on LGBT plus rights. Let us mention that in 2020 it was the Polish president that was able to say in the political campaign, fighting for his second term as the president, that LGBT are not people, they are ideology. It was the time in August 2020 when we had so-called Polish Stonewall, where a number of people were arrested for a night due to the participation in the demonstration to support one of the LGBT activists. It was the time when Polish local communities in South and Eastern Poland were adopting resolutions against so-called LGBT ideology. So these are just 3 specific examples that were showing that at that time, until 2023, there was no any chance for any positive legislation that would increase rights of LGBT plus people, but also that it was a regular practice of the Polish authorities to use and to instrumentalize different issues concerning the protection of LGBT rights in order to increase their political support. So, to be honest, when I read the judgment Commission versus Hungary, I read it from by using lens of instrumentalization of the LGBT community for the political purposes. That was the purpose of the Hungarian legislation and the policy of Orban, and that is why Court of Justice, as well as number of EU member states, were so strong in supporting the Court of Justice and the argumentation brought by the Commission that resulted in the use of Article 2 of the Treaty on European Union. But please look that, and once again, I would like to put everything in a certain perspective, because it doesn't mean that the Polish LGBT plus community was weak. Quite otherwise, during this time, the time has been used in order to increase different capabilities for advocacy, for using courts, but also for strategic litigation concerning different issues. So, for example, when you could not count on the protection against hate speech, homophobic hate speech, these were Polish NGOs and lawyers that brought a number of cases to Polish courts, claiming that in such a situation you should seek for the protection of the civil law, using the concept of so-called personal rights. Moreover, we had a series of cases. Some of them started even as late as in 2012 that concerned the recognition of same-sex couples, and those cases were brought before the European Court of Human Rights, and we could enjoy first judgments with the end of 2023. I mean the case Przybyszewska and others against Poland, and then successive other cases. But also there was a litigation that was brought by basically the same team, which is today represented by Milena Adamczewska-Stachura, by Anna Mazurczak, by Paweł Knut, and by Artur Kula. So there were cases concerning recognition of children that were born in the same sex, that were raised in the same-sex marriage, and of course the case Cupriak Trojan that has been also litigated for a number of years. And here I would like to indicate one thing. Please look that one of the reactions of the Polish state towards those cases was the prosecution service that was joining all those cases in order to protest, in order to protect alleged Polish traditional values, and in order to block any possibility for the development of the LGBT rights in this context. And why I mention this? Because please look that in the case of Cupriak Trojan, you can see that this case was joined by the prosecution service. But interestingly, prosecution service joined this case at the time when the prosecutor general was Mr. Zbigniew Ziobro. So he was one of the, let's say, hardcore politicians of the Law and Justice Party. But interestingly, the position in the case before the Court of Justice was presented already in 2024, when basically I had a pleasure to be prosecutor general, and it was the Regional Prosecution Office in Warsaw that submitted its comments and the opinion, and later on also supported the cassation appeal brought to the Supreme Administrative Court. So interestingly, the fact that I would say the previous prosecution service joined the case and the new could present the arguments was quite, in my opinion, important from the point of view of supporting argumentation of representatives of parties in this case. But I would like to say that, like, looking once again into this social and political context, after 2023, there were some attempts to regulate in a better way, the situation of LGBT plus community, and for mostly the parliament has adopted the law extending the protection against hate speech. But unfortunately, this law did not enter into force because the President Duda directed it to the Constitutional Court, and Constitutional Court, acting in a very politicized way, decided that this law is not in compliance with the Constitution, that allegedly it threatens freedom of speech. When it comes to the same-sex couples law, same-sex registered couples law, this law is right now a subject of work of the Parliament. But still, on the one hand, some people may say that it is a success that this law is in the parliament, that it is a governmental draft law, but some other may claim that it is that the fact that the law has not been passed until today is a failure. But basically, I would like to look at this broadly, that this 2023 elections brought a change, but still it does not mean that the situation is resolved. Rather, I would say we can see the strong pressure coming from litigants, from strategic litigation, from the civil society. We can see that the government is trying to do certain things, but I would say this effort is not finished with a real legislative acts that would change the situation of the LGBT plus people, although there were some positive attempts such as hate speech legislation. Okay, and here we have this judgment coming in the end of November 2025, and later on the judgment of the Supreme Administrative Court of the 20th March 2026. The judgment, which is extremely important, and Milena Adamczewska already presented most of the important aspects of this case, but I would like just to indicate three of them. So first of all, the judgment is not only implementing what the Court of Justice said, and is not only properly referring to the case law on the EU citizenship, to the free movement of EU citizens and consequent federative rights coming from this movement, is not only referring to the jurisprudence of the European Court of Human Rights, but somehow this judgment is also fighting with kind of arguments that were constantly presented in the Polish public debate as a kind of obstacle to introduce any recognition of same-sex marriage. And one of those arguments is so-called public order clause. So the Supreme Administrative Court says, sorry, but public order clause should not prevent introduction of that kind of a recognition and issuance of transcripts. The second is the definition of marriage, which is contained in the Polish Constitution, Article 18, which was always presented also as an obstacle to the hurdle in the context of the recognition. So once again, the Supreme Administrative Court is interpreting that, okay, we have Article 18 in the Constitution, but we also have protection of dignity, protection of private rights, protection of family life, non-discrimination clauses, and all of this should result in a conclusion that Polish state should recognize same-sex marriage that has been entered into abroad. So I think this dealing with the public order clause and Article 18 of the Constitution is quite important from the point of view of the judgment. But there is also the third thing, and to be honest, when I was in the courtroom listening to the verdict, I was really happy that the Supreme Administrative Court did it, because we could expect like a good judgment in this at this, let's say, declaratory level. But it was of extreme importance that the Supreme Administrative Court recognized that if this judgment is leaving any space for non-implementation, then this judgment would not be implemented. So that's why there was such an emphasis how this transcript should be issued, that within 30 days after the returning of the case file, it should be the Personal Register Status Office that should issue those transcripts. And basically the court said that if there is any problem with the IT system, if there is any problem with those typical with those columns that are used for the purposes of issuing the transcript, it should not prevent from issuing it, because if you cannot put like proper names into proper columns, you should give it on the existing on the basis of existing schedules. But basically, you should give some additional annotations where basically some of the data does not fit perfectly into this schedule, into this formula how it should be made. So basically, it was extremely important on the part of the Supreme Administrative Court that any administrative rules, any rules that are made on the basis of ordinances, should not prevent proper implementation of the EU law and also proper interpretation of the Polish legislation. And here, so we have this judgment, we are waiting for its implementation. But of course, from a political point of view, I think the government could not expect potential effects of this judgment and the, let's say, the power, the strength that is coming with this judgment. So we have still, let's say, ongoing discussions. Okay, that even if this one judgment is implemented, so how we should, how the government should approach it towards some other couples. Same-sex couples, same-sex marriages, and how the Polish ordinances, Polish law should be changed in order to make it in a unified way. And there are different versions presented in the public domain, and there are also different discussions within the coalition partners. We hope that sooner or later those discussions will finish and there will be like one single mechanism of implementation of this judgment. But what happened afterwards, which is also quite a phenomenon, is that there are some regional administrative courts that are already issuing also those judgments relating to the recognition and issuance of transcripts regarding same-sex marriages that were entered into abroad. So we had one judgment in Gorzów Wielkopolski, but we had also very important judgment issued just yesterday by the Regional Administrative Court in Lublin. This case in Lublin is very important, like personally to me, because it's quite interesting that the lady who was requesting this transcript, her name is Alicja Sienkiewicz, and can you imagine 8 years ago, she was one of the organizers of the Equality Pride in her home city, Lublin. And at that time, on this, upon pressure coming from right-wing organization, Lublin city has banned the Equality Pride in the city. And I remember, and Milena was also in my team at that time, that we litigated this case before courts. And basically, as a result of the decision of the court, this Equality Pride could take place in Lublin. I remember when we were in a court, I was also personally there. Alicja Sienkiewicz was at that time crying, and that it was possible that in her home city it is possible to organize Equality Pride, and that courts are on her side. And interestingly, also yesterday, courts were on her side in the context of the recognition of her marriage that has been made in Madeira Island on the basis of Portuguese law. So it is quite a coincidence that the same person is behind the scenes, not behind the scenes, is a major actor in those two important cases. So my point is that I think that irrespectively of what happens with, let's say, adoption of this ordinance by the government, and what, irrespectively of what happens with the adoption of the same-sex couples partnership law in Poland, I think that we start to observe a process of diversified, radiated implementation of the Court of Justice judgment. And I'm pretty certain that after those after this judgment of the Supreme Administrative Court, after those judgments of the regional administrative courts, after a situation when number of couples are already requesting those transcripts on the basis just of the Cupriak Trojan Court of Justice judgment, it will be a certain process that will ultimately lead towards recognition of same-sex marriages that were contracted abroad. So probably this legal process would happen when the Polish state is maybe not responding fully with its legislation or with its ordinances. And in my opinion, it is a great effect how the EU law operates and what are the potential consequences of the EU law, of the EU Charter. Just maybe last point to say, please look that the Supreme Administrative Court clearly did not indicate what are the consequences for different aspects of the material law, for civil law, for labor law, for family law, and so on regarding the judgment. But interestingly, there were already declarations from certain offices, and especially here, I would like to mention the Central Social Security Office that said that we are going to recognize the Court of Justice judgment. And that kind of a declaration saying that, okay, for the purposes of the social security, we are recognizing same-sex marriages contracted abroad. I think it is a great sign, how this whole process may go out as a result of, let's say, this decentralized effect, but also a little bit like, I would say, like diversified political approach within the ruling coalition towards this judgment. Thank you very much for your attention.
Thank you, Adam, and thank you all of our speakers. We have some time for some questions. I suggest, can you raise your hand if you would like to ask any of the speakers any questions? And we'll take a few questions at the beginning and then we can allow for answers. I'm going to use my position as the convener to ask two questions first, though. So my first question is following on from comments that were made by Milena and Alina about this status issue and looking back on how this judgment of Cupriak Trojan goes further than Pančerevo, Mirin. And as I understand it, like correct me if I'm wrong, like I see this case as different because it deals with charter rights to equality rather than derived rights of free movement that attach to citizenship. And I see this judgment as being quite revolutionary because I would understand it as a mutual recognition case that if a member state allows European citizens to acquire the status of marriage in a member state, then another member state cannot refuse to recognize that. And if they do, then it would have to be subject to some proportionality test and before a justified reason. And then I would understand also then from last week with Commission and Hungary that because it is not allowed under Article 21 of the Charter to ever discriminate on the basis of gender or sexual orientation, that it could never be the basis for a public order exception to mutual recognition of a marriage acquired in another member state. I don't know, like maybe if you have an idea of that. And my second point was about something that Catherine had mentioned about Article 2. Like I'd had the same thoughts since Cupriak Trojan that maybe this is going to be used as the basis for populists to treat EU law as being the enemy itself because it is overly liberal and protecting interests which they might be opposed to, and that this could lead to further divisions in society. And then when I think about like the structure of the argumentation of the Court of Justice last week, what I found really interesting, because in the commentary afterwards, there have been predominantly arguments that it's a legitimacy issue. The court has gone further than its mandate by and exceeded the limitations of the application of the Charter. But in the arguments, as I understand it, the court first of all said that the EU is its own constitutional order. It then said that as the supreme constitutional judicial body, under Article 19, it has the authority to interpret EU law. And then it moved on to treat the breach of the charter rights within the scope of Article 2 because it's part of the constitutional legal order. And like I would understand that as this is a court doing what courts do, acting in a counter-majoritarian mandate to protect rights of minority groups in society, rather than this is EU law is protecting against this populist idea. And I was just wondering if anybody had any thoughts of that, because I haven't seen anything written about it yet. So those are my two questions, and they're open to anybody. So does anybody else have any questions? If you can raise your hand, then I'll call out your name and you can ask your question. So we have one question from Marie in the chat box. Does anybody else have any questions? Okay, so we can start with that. That's a question for Milena or Alina. Do you think this judgment, if it is applied by analogy to parent-child relationships, could have a positive impact on how Pancharevo is implemented in Poland or other countries that have not implemented it? Zuzi? Do you want to ask the next question?
Yes, hello everyone. I just wanted to add a question that came up in the Czech context, and Alina already mentioned it a little bit, whether it does or doesn't follow from Trojan that downgrading would not be acceptable. So entering into marriage in one country and being only recognized as partners in another, because this is really keeping lawyers busy in Czechia, and we really see it coming as the next phase. And pretty much where the disagreement lies is whether Trojan answers that question in favor of the same-sex couples, or whether it leaves the question unanswered on the downgrading. So I'm just curious if anyone has a strong opinion on this one. Thank you.
Okay, so would you like to answer those questions? So first of all, there was the question to Milena and Alina.
If that's fine for you, Alina, I can start because actually I also kind of have a question to you. So I'll answer and maybe then take it to you. Thanks everyone for your contributions and for these questions. And maybe I'll start with the Pancharevo question we had in chat. And actually, for a Polish Supreme Administrative Court, these situations of married couples and children with foreign birth certificates with same-sex parents is very similar, and it's actually so close that all the proceedings we had in the cases of transcription of birth certificates were put on hold until the time that we get the CJEU judgment and Supreme Administrative Court judgment in Pancharevo, in Cupriak Trojan. So we are actually currently waiting for these proceedings to be put for the court again. And we are actually almost sure that we will win these cases in favor of transcription of birth certificates as well. So it will be I think as full implementation of Pancharevo as we can imagine. It's discussable whether what we have in Poland now with only IDs being issued. So the question of recognition is there. It's not recognition of parenthood of both parents, whether it is actually enough to implement Pancharevo or not. In my opinion, it's not. But transcription of birth certificates for sure will recognize family rights of the whole family and parental rights of both parents. So in that manner, like I think that in Poland, it should be a huge change. What we got in Cupriak Trojan also for these cases, it's a little bit difficult for me to say like how it will be in other countries without knowing specific legal contexts. And now going back to the question of let's say downgrading and this content of recognition, as you put it, Alina. I actually can't stop wondering what if Poland already had civil partnerships in what, like, let's say any form, right? Because the bill we have now in the parliament, it's very limited. It's not even establishing a family law institution. Like the proposal is to establish a sort of civil law contract between partners, which will not amend civil status of a person. So in my opinion, like there is no way that this kind of institution would implement Cupriak Trojan judgment because the court is very clear there that the actual recognition of civil status of a person is the key element. So if we had this kind of civil partnerships, like I think downgrading is not an option. I'm not really sure what would be the case if we had stronger civil partnerships or if any other form of recognition would be possible. So this is the question that you also mentioned, Alina, like what way of recognition could it be, right? Like in Poland, it's only transcription and we want to stick to that. So this is my answer. And I also have a short question to you, Alina, about the parenthood effect, because that really kicked my mind. And I'm already thinking, of course, about further strategic litigation, because actually, like I thought until now that the court was clear that the effects should be only for the rights that citizens of EU can exercise under EU law. And parenthood like is clearly not there. So like I was wondering like how do you see that, and if this is not the limitation for this type of rights? Thanks.
Alina, would you like to go next and then Catherine?
Yeah, sure. So, okay, wow, quite a few questions. Right, so in terms of the parenthood question, to start from this, because, or shall I do the downgrading? Actually, I will do the downgrading. I think this case, the Cupriak Trojan case, was actually rather easy, exactly because it was easy for the court to say, okay, the only way is transcription, it has to be like this. But it's clearly by making also reference to the Strasbourg case law, which accepts the possibility of downgrading and does it explicitly with cases like Orlandi and all this, the court seems to be accepting it. However, if we really read the judgment carefully, this judgment, then we see that, well, how is it possible to accept that same-sex married couples will be downgraded when they move, whereas the different sex ones will never be downgraded? So I'm wondering whether the court actually wanted to pay more attention to and to emphasize the obligations under Article 21, exactly in order to prepare, you know, the whole argument for a next case which may raise this question. So currently, we don't know for sure. It's, as I said before, it's one of the possibilities that the downgrading may be possible, but we are not sure. But personally, I think, how can you say that they have to be treated equally with different sex couples and then say they can be downgraded? So that's my personal view. In terms of parenthood, well, and that's also the question of Marie. When it comes to parenthood, I think, first of all, this case clearly can have implications for that as well. And answering to Milena's question regarding parenthood, yes, it's a national competence, and whether someone can be a parent and whether same-sex couples can become parents, joint parents, is indeed a question of national family law. But in my view as well, when it comes to, as I said in my presentation, it's not clear which rights will be coming to the married couple, will be given to the married couple following the ruling in Cupriak Trojan. At the same time, I don't think it's only EU rights. Because if it was only EU rights, like the right not to be discriminated against on the grounds of nationality as regards, let's say, social assistance benefits and all these, that was already there following the Pancharevo case, not Coman, because Coman was specifically about the right of residence. But in the Pancharevo case, it was already said that, well, they are entitled to all the rights deriving from EU law in a way. I think it goes further, and it goes further because it's not only a case about, as I said before, access to the right to free movement and residence, but it goes further. The court emphasizes the right to lead a normal family life. How can you lead a normal family life if, okay, you are recognized as a couple, but then you don't enjoy any rights as a couple under national law? Succession rights, for example, when one of the spouses passes away, well, obviously it's very important for them to know that the other will be able to inherit that person. Succession rights, again, are things which are regulated at national level. They are not EU rights. So personally, I think for sure, because you know, it's something that really comes even with registered partnerships, that inheritance rights are granted, that so couples that benefit from this judgment will be able to claim succession rights. And for sure, they will be able anyway. These are guaranteed under the European Convention on Human Rights as interpreted by the European Court of Human Rights. The reason I singled out parenthood rights are exactly because the European Court of Human Rights, with regard to parenthood rights, is keeping a step back. So with regard to those, it's one of the few areas that said, well, no, we shouldn't treat same-sex couples in the same way as different sex couples. And in particular, it said that if states reserve parenthood rights only to married couples, even if this means effectively different sex couples, because it's only them that can marry, that doesn't amount to discrimination. So my view is that downgrading, it seems possible under the ruling, but someone who reads the ruling carefully and sees the importance of non-discrimination, well, starts thinking, well, in the future, in reality, this will not be possible. And then when it comes to the actual rights that can be enjoyed by married same-sex couples that move, for sure, it's EU rights deriving from EU law, but also certain rights deriving from national law, at least those that have been recognized under EU law anti-discrimination, at least, and the ECHR, the European Court of Human Rights. But then we have this small pool, let's say, of rights, which even the European Court of Human Rights didn't dare to touch, like parenthood, that we will need another case, I think. And even then, I'm not sure any of the European courts will really dare, especially under the current climate, to really move forward. But I hope I'm just pessimistic.
Okay. Catherine, would you like to?
Yeah, I will be brief because I realise our time is virtually up and I know people have got to leave. I just want to say, first of all, I think it's fantastic to see these passionate lawyers using law for the way that a lot of people went into law, which is to bring about social change. It's really moving. And I also take my hat off to the claimants in this case, because you need to be very brave to bring this sort of litigation. And so I think it's wonderful. My slight cynicism is only because I've spent the last 10 years talking about Brexit, and I know what those people who are very hostile to any aspect of the EU project, how they can use some of these judgments and what is happening, particularly over language like values. In respect of values, my question is simply, in the Hungary case, given that the court had found a breach of all of the charter and all of the the primary treaty provisions, what extra did finding a breach of Article 2 add? And I would say on that, the finding a breach of Article 2 seems to put Hungary not just on the naughty step, but being sent right out of the room. I see it as a more political decision on that point rather than a legal one.
Okay. Thank you, everybody, very, very much. I suppose the last word I can give to the claimant.
Thank you. I'll try to be brief because we're out of time already. First of all, thank you everyone for your contributions. I have learned a lot about my own case and its importance. Second of all, I don't have any question, but I just have a piece of information for you. I'm already thinking of another set of facts to keep courts busy and lawyers busy. And Germany has introduced a new law on self-determination about 2 years ago. And this law on self-determination includes not only two legal genders, but 4. There are 4 options in Germany: male, female, diverse, and there's also a 4th option, which is just no data. And I am actually, as soon as I get my Polish marriage certificate, I'm intending to change my legal gender in Germany to no data, and to have it maybe in the future recognized by Poland. We'll see how it goes. We have the Mirin case, of course, which can be a good basis for that, I guess. Although I know that Mirin is only binary. It's only male to female, I guess, as far as I remember. And here, this will be a non-binary case, but I hope I can succeed at some point. It's not, the idea is not really complete yet, so I might have to wait some months or even years and reconsider it again. But it's just an idea that I'm having to so to say, to keep Polish courts busy and maybe to keep European courts busy as well. We'll see. But thank you again for all the contributions, and thank you for this for the opportunity to take part in this debate here.
Thank you. Keeping courts busy is a good thing. Thank you so much, everyone. That was really wonderful. Thank you for all of your contributions. Thank you to everybody for joining us today. I wish you a fantastic rest of the week. Thank you.
Thank you. Bye.
Thank you.
Thank you very much. Thank you. Bye-bye.